These are not set up to help the defendant in any way, shape, or form. There is some access and ability to it, but these are highly in favor of the national security secrets, as we saw with Trump. We're like, he was the president. He saw everything. Like, sorry, can't see it again.
And they're trying to sway the courts through the media, through the court of public opinion. They're trying to muddy the waters enough because they know that the Trump Department of Justice can get convictions on these.
Bolton was entrusted by the president to handle classified information appropriately. And if he's found guilty, he should be held fully accountable. John Bolton's lawyer, Abby Lowell, screwed up. Here you can see the court called him out. Abby came in and he said, I'd like to file a proposed sealed document entered in there. And what we know now that we have the corrected filing is that he wants to leave the country, looking to go on a little speaking tour over in Europe or something. And so we've got the final document that came out here, and we'll look at what's going on, the latest with John Bolton's case, because the government is also now disclosing some of their classified information procedures over to the court, hoping the court will start to set the rules on this so that the discovery process can continue. We're talking about national security documents from John Bolton's wife and daughters and their home and email accounts that were hacked by the Iranians. Now, here's what the motion actually said from John Bolton. He wants to go on a little trip. Defendant John Bolton is now filing his request for international travel, and he wants to submit the actual motion under seal. This is permission to file the other one under seal. So Abby, he came back out and he submitted this one. He's like, oops, resubmitted it. He says, here you go. John Bolton is now asking this court for permission to go on international travel. Pursuant to the rules, we know that his conditions of release that we talked about require approval in advance if he's going to be traveling outside the continental United States. Now, as indicated by Ambassador Bolton's counsel, during his initial appearance, he was previously scheduled to go speak at a conference in Europe in early November 25. Wonder what that is. Good cause exists to allow Bolton to file this request, which includes detailed information about his upcoming travel, itinerary, all those things under seal. Now, Bolton has previously been the subject of credible safety and security threats. For example, in 2022, a member of Iran's Islamic Revolution Guard Corps was changed for attempting to arrange the murder of Ambassador Bolton. Then they hacked his emails and he didn't tell the FBI about it. He continues to face such threats and requires around-the-clock security protection. Yeah, and I guess they'll go overseas with him. So he seeks to provide the court with sufficient details about his proposed travel, and if he publicly files that, we're all going to know that he's going to go meet with Zelensky or Macron or somebody. Accordingly, Bolton respectfully requests that you allow us to file this under seal, and of course the court is going to allow that to happen. Now, the DOJ also submitted some other documents. Now, this prosecution involves the unlawful transmission, communication, delivery, and retention of national defense information. We've already determined that we got to give some of this stuff back over to John, and at least some of these documents will comprise part of our proof at trial. So we're going to give it to him and use it. We also anticipate that we may need to make certain pretrial rulings to discuss the actual evidence. And so accordingly, the Classified Information Procedures Act, CIPA, will play a significant role in this case. We filed this memo to let you know about the procedures and how we think we should handle all of these matters. We also ask that you appoint a security officer to handle this stuff and set a pretrial conference at the same time as the initial status conference so that we can get into the nuts and bolts of this. So here's the background. John Bolton, charged 18-count indictment, willful transmission and retention of classified information. Speedy trial says the trial shall commence on or before January 30th, and the clock is ticking, including the national defense information that, in other words, I'm not sure that this case will actually go on January 30th next year. Classified information, including national defense information. He's charged with retaining a bunch of these things, and CIPA needs to come in because if we disclose this stuff to him, it's going to raise issues of national security. And so the rules authorize us to ask for a pretrial conference, which is what we're going to do. Now, a lot of this case, just background stuff, overview of the act. Congress passed this puppy in 1980. It doesn't change our discovery obligations. It doesn't alter the rules of evidence. All it does is mandate a number of procedures at pretrial, trial, and appellate stages of the criminal case to balance the defendant, in this case John Bolton, and his rights to due process, including the right to a fair trial, against the government's interest in protecting classified information, sources, and methods. This interest applies in both discovery and trial contexts. And the Supreme Court has weighed in on this. They know we got to protect the nation's secrets from disclosure, which, I mean, everything is secret. You know, we know nothing about stuff we should know about, but all right, in this case, it's secret. Fourth Circuit has also stated that CIPA gives district courts wide latitude to handle these matters. The U.S. may produce discoverable valuable material to the defense, and we want to make sure that it is protected. And so accordingly, you can assess to what items classified information procedures should apply. You must go through this procedure, right? Is this discoverable? Is it something that we can pass over? The court must assess if there's privilege over it. And third, the court must consider whether it's even relevant. Is it even helpful to the defense? Classified information that is not helpful may be deleted. That is, it's withheld from discovery. They can't even see it. We saw that with Trump. Classified info that is relevant and helpful must be produced to the defense. And so the defense might say, that is going to be helpful to us. Like, we want that. We might use that. The court says, well, you can't use it because it's not actually helpful. And this could actually have substantially the same ability to make his defense as would disclosure of other information. So they give us definitions here. Comes out from these statutes. Pre-trial conference, you're allowed to ask for one. They ask for a protective order. It says the court shall issue a protective order following the rules. And there's a lot of details, okay? Protection of information during discovery. If you determine, judge, that the information that's classified is either not relevant to the determination of guilt or innocence, or if it's helpful, you can withhold disclosure of that information, which as a defense attorney, you're like, I want it all. I want everything. CIPA also says that the government may demonstrate that the use of alternative discovery like deletion or substitution is warranted. A security clearance at a given level is not sufficient to entitle any individual to access that stuff at that level. Rather, the courts can make that determination whether it's need to know. Need to know as defined as a determination within the executive branch that a prospective recipient requires access in order to perform their lawful functions. And a defendant, in this case Bolton, may be entitled to notice when the government initiates CIPA proceedings, and there is no due process right to receive a description of materials that are not discoverable. Only if the information is discoverable must the court then examine if it's also helpful. And there are 3 critical steps to this. They got to specify the info that they want. The court then has a hearing, and then we talk about the admissibility of the evidence. And third, following the hearing, we may substitute other materials. Like, we don't want that actual document. We just make an admission, a proffer. And the defense has to disclose stuff too. If they fail to provide notice far enough in advance of trial, then they just lose the right to do it. They don't get access to it. These are not set up to help the defendant in any way, shape, or form. There is some access and ability to it, but these are highly in favor of the national security secrets, as we saw with Trump. We're like, he was the president. He saw everything. Like, sorry, you can't see it again. Any hearing in this case shall be held in camera, that is in judges' chambers at the request of the AG. In connection with the hearing, the government may submit an affidavit from the AG saying that if you disclose this, right, so the Attorney General, Pam Bondi, can step in and say, nope, you're not going to see it. There's identifiable damage to national security, and so the defense can't have it. Then the court can look at it, and the court shall seal and preserve all the records, because we can't see anything. Like, we're just citizens. We're like peasants, you know? If the court determines that an item of classification is relevant and admissible, the government may object to the disclosure, and then they may issue an order to the defense, don't disclose anything. Now, you might also want to appeal this. So like, if there's a bad ruling, this is how the appeal works in the middle of the case. Don't have to wait to the conclusion of the case. If an appeal is taken, trial doesn't commence. It pauses everything while you appeal this disclosure. Bolton says, I need that. Government says, no, you don't. Appeal, fight over it. Everything pauses until we're back down. Section 8 then is about introducing materials to prevent unnecessary disclosure. This permits a court to order the admission of evidence, only part of it. So you don't need the full document. You can just submit portions. And if you need to do an examination, the government may be able to offer a proffer. There are also security procedures that they should go to, and the government is now making the request. So we're in the process, writes Maryland, of identifying and reviewing material that is currently classified. Some of this material may be subject to disclosure in advance of trial, could raise national security concerns. And so we respectfully ask that you schedule a pre-trial hearing to go through these issues, and we'll give you an update how much time we think once we do our work. Because of the nature of this, we can't give specifics in open court, but we could do it ex parte in an in-camera hearing. So only the judge and the government in the judge's chambers off the record, behind closed doors. As previously noted, the courts have consistently held that these are proper. We also want a security officer to come in, and here are the people that are available. Bunch of names listed here. A proposed order is also attached. There's going to be a bunch of classified stuff going back and forth, and so we need a hearing and we need an officer. This is in the Bolton case, and the judge is granting the speedy trial. Yeah, so here, the time from October 17th shall be excluded, and so we're just keeping our eye on the next dates that are coming up. But you remember this woman, Christina Bobb. She was Trump's attorney and highly involved in the Mar-a-Lago case, and she was asked about John Bolton since she's got experience with classified documents prosecutions on the receiving end. Here's what she said.
How much legal trouble is he in?
A lot. lot. I can tell you, as a criminal defendant myself, any criminal case is a lot of legal trouble, but 18 counts violating unlawful disclosure and retention of classified materials is nothing to laugh at. It's far more significant than what they charged President Trump with. President Trump was supposedly obstructing justice when they were trying to investigate him. I mean, they have 39 counts of that. They never once alleged that he unlawfully gave anybody else access. They were just saying that, he was sloppy in how he maintained his records and he obstructed justice was basically the allegation, which, again, no victim, right? But with this, they're saying that he was actually disseminating classified information. And I will also highlight that this comes from a Maryland grand jury. This case is filed in Maryland, which is a very liberal district. So he has a favorable jury pool, and they still found enough probable cause to indict him.
And speaking of liberal grand juries, and look, this is why I say to the Democrats, relax. The grand juries are coming from Maryland, from dark blue Northern Virginia, where James Comey was indicted for lying to Congress. Tish James was indicted for mortgage fraud. I mean, that's how the system is supposed to work. The grand jury takes a look at the evidence presented. They make a decision. Usually it's about 25 people. You never know who, and they never disclose the conversation. But that's why the system is in place, to make sure that people that get indicted for the right reasons, correct?
100%. And they're trying to sway the courts through the media, through the court of public opinion. They're trying to muddy the waters enough because they know that the Trump Department of Justice can get convictions on these because there's enough evidence to actually get convictions. And so they're trying to foment enough discussion about this negatively towards the Trump DOJ to try to get the courts to throw the cases out because they have liberal juries. They also have liberal judges in these areas. And so they're trying to create enough of a shield for these judges to dismiss the case. If the judges follow the law, the cases should not be dismissed, as far as I can tell. There hasn't been anything that I've seen reported that's improper about any of this. But, I mean, it's a battle. The venues for all of these is against the Trump DOJ.
Yep, and now Bolton is having to face the music. And Bolton was one of those guys who was repeatedly out on the cable saying anybody who did anything bad with classified information should even, in some cases, get the death penalty and be locked up forever. He was very excited about that. So Brandon Gill, another congressman, he posted this one today. He said, Bolton was entrusted by the president to handle classified information appropriately. And if he's found guilty, he should be held fully accountable. Brandon Gill, congressman, saying the following.
It seems like the Biden administration recognized that John Bolton was a critic of President Trump, and they didn't want to bring charges against somebody who was attacking, at that time, their political opponent. That seems to be the politicization here. Again, these are very serious charges. This is information that can get people killed. This is government, military-related, national security-related information, and we've got to take that seriously. I think we've gotten a little bit lax in certain areas about where classified information, top secret information goes, and this is somebody who is entrusted by the president and, by extension, the American people to deal with this information appropriately, and it doesn't look like he did.
Yeah, and that is from Brandon Gill. And what John Bolton did was a plot. Before he even came in, the day before he got the job, he was creating this little group chat with his wife and daughter, and then exploited that the entire time, all with the pretext of writing a book. Who knows if that's true? He definitely did write a book, and it was filled with classified information, but is there anything else there that went on? And the guy also sent classified documents and materials to himself via email to AOL, an AOL account that the Iranians hacked. So every criticism that he lobbied against Trump and others, he was the one committing, which is the standard for many people who are part of the deep state operation. I was going to say Democrats. He became a Democrat adjacent individual, but they commit the offenses and then accuse everybody else of committing the offenses. And in many cases, will prosecute them and try to imprison them for that. And John Bolton was never the president.